One of our people at the speaker's table must leave, so I just can't help but start my remarks while the young people are taking care of the dishes and so on, because I had wanted him to say a few words, but since he is going to leave, I'm not going to give him time for that. But then unless he wants to rebuttal. But Dan Griffin is our director of the Iowa State University Research Foundation, and he is here tonight as the developer's attorney. And talking about attorneys, Dan was as a defense attorney for a court case recently, and as they usually do, although we are not going to do that tomorrow unless they change the rules. He was questioning some of the jury in selecting the jury, and there was this old cantankerous man as a candidate for the jury, and then says, do you know who I am? And the man said, yes, I know you are a crook. So Dan very quickly pointed to the plaintiff's attorney and said, do you know him? And the man said, yes, and he's a crook too. So at this time, the judge calls Dan and said, would you please approach the bench? And he whispered and said, if you ask one more question, I'm going to cite you for contempt of court.
You're right.
You want any rebuttal?
No rebuttal at all. New Lex does fit that.
Just laughing.
So you are free to leave anytime you like. Thank you. Thank you very much, Dan. And he's going to be working tomorrow.
You'll lose.
Please don't prejudice the audience. As I mentioned, and I understand that Mary Atherley very concernedly asked some of the Ames city staff members that did we really promise to pay for half the bar? Well, I promised that while introducing Mary again, I would not ask or give any obligation for her to speak, just the right to do so. So,
I'll pass.
She'll pass. Thank you very much, Mary. So, at least in spirit, you're our gracious hostess tonight. Then I'll turn to the other end, and as it happened, Jerry Knox, I think he's going to be back here, but I had his place filled this noon by the old farmer who has been a farmer here for 30 years, and who just all of a sudden has found that the Southgate Incorporation has made him an offer for his farmlands at $9,000 an acre.
We can buy a lot of pheasants.
Bill, are you going to take the offer? He may be on the other side tomorrow. Of course, I was really delighted that I had Alan Felt to be here as a speaker tonight. Alan and I met a number of years ago, and we worked on a statewide computerized population model and various other things. Alan, would there be any things that you would like to say?
Can I take 1 minute?
Yeah, you might even say something about the business of the what's going to happen if you want to. Come on.
I don't know what'll happen tomorrow. Any more than, well, I'd like to clear up a couple of points on the exercise today. We did not know how the Common Council was going to vote, and we're just as surprised as some of you are that the vote was unanimously opposed to the rezoning. We didn't, in these kind of exercises, you're never sure what's going to happen. I would further like to point out several people have commented on the quality of the exercise. They thought it was pretty good. If there was good quality, it's because first the preparations by the Iowa State staff, which were superb in terms of the presentation on the site, but second because of the participation of you. I had almost nothing to do with it. Eno had a little more to do with it, but an exercise like this rests on the people who are participating. And so far it's going pretty well. We'll see what happens in court tomorrow. I have one last point I'd like to make, just maybe to stir up a little tension tomorrow. At least 5 people have stopped me and pointed out, and all of whom were developers in the real world, not in the game. In the real world are developers, and pointed out that there logically should have been some support of the development proposal today, because it wasn't a bad proposal. And all I can say is maybe you ought to get your stuff together and present some arguments in favor in court tomorrow. There are logically some arguments, and maybe there's some relationship between reality and the game in terms of not having a good enough or a tight enough or a loud enough presentation in favor of capitalism and free enterprise and whatever it is you're going to argue for tomorrow. But there logically are some arguments in support of the development that maybe should be brought out tomorrow. And if you don't fit one of the roles that where you're assigned or one of the interest groups, there ought to be a place within the court proceedings for some arguments in favor of the local poor downtrodden developer being beaten to the wall by all the local planners. This is probably generally a prejudiced group in terms of being representative of planning and long-term interests, but there's a place for the local businessman here, and I hope maybe you guys can get together and make a pitch tomorrow. But in the meantime, if the game was successful today, it's thanks to you and to the Iowa State staff. The rest of us had relatively little to do with it except to arrange the chairs. Thank you.
Well, we are coming to one of the highlights of our workshop again tonight, and I think the allusions have been made all the time that this is really in many ways a legal case. Now, many of us don't know much about legal things. I think if it was for me, the attorneys would earn less than the medical doctors do. But I hope that they'll make a living one way or another. And the gentleman who is going to speak is kind of a mixed creature in a way that he is both a planner and an attorney. He thinks that planning law is more interesting than labor law. I don't know whether there's some love of labor lost or what. How did that come out? Well, he has grown in Pennsylvania, and he has had some experiences in Vermont, if I'm correct. No, I guess I'm mixing with Jack Peters. But anyway, he has ended up being in the Ohio State, and Ohio State is a little college that sometimes plays Michigan in about the last game of the season, football. They have a fellow out there, and you already got an idea that I'm a little bit of a, let's say, expert on the heavenly things. There was another guy who was in a gatehouse, and he was being indoctrinated. And while this was going on, a small, fat character with a sweatshirt and a whistle hanging from his neck was coming in and out of the St. Peter's Gatehouse. And while this new soul was being introduced to Gabriel and Michael and all the other angels and saints, he never was introduced to this old gentleman. So he finally said, now, who is this guy who keeps coming, the one with the whistle and the sweatshirt? And St. Peter said, psst, he's God. He thinks he's Woody Hayes. Now, I think I'm not going to go any further. Ken Perlman from Ohio State.
Thank you. After an introduction like that, perhaps I ought to pass and leave too. What I'd like to talk about tonight is a discussion of land use law and zoning in the 1970s. Eno had said that most of you were not legally trained, and therefore I'm going to keep this fairly general, and for those of you who are, I hope I at least can provide something of interest. Probably no recent period has seen as much advance in the area of land use laws as the 1970s. There's been a substantial amount of activity in the courts, and a lot of hot arguments on both sides of a number of issues. One thing has been the Supreme Court of the United States has, for the first time since the 1920s, entered into the land use game and has issued a number of important decisions which have shaped land use law as it is today. In addition, after the environmental movement of the 1960s, a number of federal laws were passed in the environmental area, and these laws have, in effect, provided an overlay on the traditional local land use and zoning controls. In addition, there have been in most major cities in the country lawsuits filed on school desegregation, and some of the decisions which have taken place will have or have had an effect on regional development. And in addition, in the area of schools, almost every state school financing law in the country either has been, is, or was under attack on the grounds that the method of financing the schools through the property tax was unconstitutional, either because it denied equal protection or it failed to provide a fundamental education as required under the state constitution. The implications of this set of cases is also very broad and will have some effect on regional development and growth control. What I would like to talk about, concentrate on largely, are the cases in the area of zoning, with some discussion at the end about environmental litigation. Now, as I'm sure all of you are familiar with, zoning is the principal method of controlling land use. And what I would like to talk about is the expansion of the concept of reasonableness under the zoning power. As you know, the power to zone is an incident of the police power to promote the public health, safety, morals, and welfare. And although lawyers and judges approach zoning cases in many different ways, typically there are three problems which arise in almost any zoning case. The first is whether the ordinance can be said to reasonably relate to the public health, safety, morals, and welfare. Or in other words, does it serve a valid public purpose? Second one is related to this, and is the question of whether the means used to achieve this public purpose are reasonable. And the third is the question of whether there's been a taking. One could spend a lot of time on all of these. I want to talk principally about the first one tonight, the public purpose of zoning. And typically, courts will uphold a zoning ordinance unless its provisions are clearly arbitrary and unreasonable and have no relationship to the public health, safety, morals, and welfare. So you have to have a reasonable public purpose, and you have to have means which are reasonable to achieving the end. And the burden is on the party attacking the ordinance in most circumstances. And this is important because, as we'll see later on, in certain classes of cases, the burden shifts. Cases which are most importantly concerned with growth control. What has happened in the past 50 years or so, very gradually, is an expansion of the concept of zoning as seen by the courts, of the concept of what is a reasonable public purpose. Land use regulation, I guess, arose largely out of nuisance regulation, resolving disputes between landowners. Somebody's cow runs onto somebody else's property, and that causes a nuisance. There are many early statutes in both England and the colonies which related to nuisance regulation, and I have on occasion had a chance to look at them, and I'll give you just an example of a couple. England at one time had a statute which was ordered the widening of highways to prevent a situation where a man may, quote, lurk to do hurt. They also had a statute to prevent, quote, great and outrageous fires. And they also had a statute directing the prohibition of steam engines near public roads. You can see the purposes here. One doesn't widen highways so the horses and carriages can go through. One widens highways to prevent crime and to prevent nuisance kinds of activities. And in colonial America, there were similar kinds of regulations. In addition to the statutes, there also was a large body of common law, judge-made law, in the nuisance field, and there still is today. And a lot of land disputes can and are regulated by nuisance cases in the courts as litigants between private parties. In the early 20th century, zoning and planning cases relied on nuisance. Some of you may be familiar with the case of Hadachek versus Sebastian, which outlawed a brickworks in, I think it was the city of Los Angeles. The brickworks had been built at a time when it was considered perfectly acceptable, and subsequent development around it created a nuisance, and the court ordered the brickworks to be shut down. The first major Supreme Court case on zoning was Euclid versus Ambler, decided in the 1920s, and that was a case involving a typical zoning ordinance which divided land into a number of different use districts, area districts, height districts, and also contained things like setback restrictions and lot line requirements and the like. The purpose of the ordinance was largely to control and order uses, to prevent incompatible uses from existing side by side with each other. And the court, in its decision, relied strongly on zoning as an extension of nuisance law. One of the issues was the question of mixing apartments and single-family homes, and the court went on to, in a sort of an ad nauseum discussion, relate the problems of mixing apartments and single-family homes. And it said, and I quote, "Under these circumstances, apartment houses which in a different environment would be not only entirely unobjectionable, but highly desirable, come very near to being nuisances." And it was this relationship to nuisance that enabled the court to uphold the zoning ordinance. There was one subsequent case the following year in which the court overturned the zoning ordinance, not on the grounds that the public purpose was not valid, but on the grounds that the ordinance as drawn with respect to a particular property was invalid. And after that, the Supreme Court stopped hearing zoning cases for many, many years. They did, however, begin to expand the concept of what was acceptable in terms of planning and zoning under the police power. In 1954, there was a famous case of Berman versus Parker, which those of you who went through planning school, I'm sure, studied. And that case upheld the redevelopment program in Washington, D.C. Gentleman who owned a property which was perfectly sound and complied with all the codes, and which nevertheless was being torn down as part of a redevelopment project to be resold to private developers, claimed that this was not a valid public purpose. He had a perfectly good building and they couldn't tear it down. The court said, again I quote, "If those who govern the District of Columbia decide that the nation's capital should be beautiful as well as sanitary, there's nothing in the Fifth Amendment that stands in the way." And this represented a movement away from the concept of regulation or zoning for the purpose of preventing nuisances. Planning can be used for aesthetics as well as nuisance, and even where private developers benefit. And the case made planning a kind of a positive value rather than simply a matter of negative regulation. Now, it was not a zoning case because it involved eminent domain, and there is, I think, some argument for distinguishing between the two situations. But nonetheless, subsequent courts cited this in zoning decisions, and the Supreme Court itself cited it in zoning decisions. One interesting thing about the case was that you'd be curious to see whether they would be so free about the redevelopment program if it were decided today after we had the kind of experience we've had under redevelopment. 20 years after Berman versus Parker, in 1974, the court decided Belterra versus Boras. And this was a community with an ordinance prohibiting more than two unrelated individuals from living together under the same roof. And, excuse me, Belterra was a town which had a large college student population, and their purpose was not to prevent increased growth and increased population, but rather to keep a number of college students from rooming together in large numbers. And the court said, and it was the same judge who wrote the decision in Berman versus Parker, Justice Douglas, "A quiet place where yards are wide, people few, and motor vehicles restricted are legitimate guidelines in a land use project addressed to family needs. This goal is a permissible one within Berman versus Parker." Now, although family needs were not cited in Berman versus Parker, and single-family goals were not cited, Douglas essentially took the concept of zoning for aesthetics or zoning for positive public purposes and applied it to this. And he went on, the police power is not confined to the elimination of filth, stench, and unhealthy places. It is ample to lay out zones where family values, youth values, and the blessings of quiet seclusion and clean air make the area a sanctuary for people. This case is probably, at least in my opinion, the most important single zoning case that the Supreme Court has decided, and probably the most important single decision in the planning area that we've had, certainly since 1970. Even though it was not, as I said before, a case involving growth control. First of all, the court greatly expanded, I think, what was in Berman versus Parker, to including within the public notion of the public purpose the social values of low-density development. Under the United States Constitution, and this applies only to the United States Constitution, communities have been given virtual carte blanche to adopt any kind of lifestyle, although there have been some restrictions later on, and in effect adopt certain kinds of population levels, although courts tend to look askance at actual numerical limitations. But the Berman versus Parker did seem to say that low-density development was perfectly okay with the Supreme Court, as long as the ordinance is reasonably related to social values inherent in the public welfare. And as a practical matter, since the burden's on the party attacking the ordinance, most ordinances of this type will survive in the future. The case is also important because it dismissed a number of challenges to growth management ordinances which had been applied by a number of courts and which most courts, except for the Supreme Court, I think were willing to buy. At least the lower federal courts were. Now what I'd like to do is examine these grounds which were raised because Belterre represents a kind of watermark in zoning litigation. Up until this point, it appeared as though the courts were going to be very active and use federal law to limit the use of ordinances which restricted growth. After Belterre, there was a rather substantial retreat from that position. Typically, there are two kinds of attacks on growth control ordinances. The first involves allegations that there are violations of fundamental constitutional rights, First Amendment rights or other rights, right of association, right of privacy, what Professor Catanese mentioned today, the right of travel. And that's one broad area of attack which has been made. The other area is that they're exclusionary, and that they deny equal protection of the laws. And then there's a third area involving state cases, which I'll talk about later, which has been used to invalidate zoning ordinances on the grounds that they do not take into account the regional welfare. But on the federal level, there are two: the fundamental rights and the notion of being exclusionary. Now, generally, if there's a violation of what are called fundamental rights, or if there's a suspect classification involved, and suspect classification means an ordinance which discriminates largely on the basis of race, although there are other categories as well, but race is the principal one, then the burden of proof shifts to the state to show that there's a compelling interest in the ordinance. In other words, it's no longer the burden on the party attacking the ordinance to show that the city is being unreasonable. The state has the burden, and furthermore, it cannot simply show that what was done was reasonable. It has to show that it was compelling. So the traditional planning justifications, sewer lines would be expensive, there'll be some overcrowding in the schools for a while, things of that nature would not pass muster under a compelling interest test. And this is an important factor in who wins the case. And in fact, in most situations, if you can classify the case as a violation of a fundamental right or involving a suspect classification, the community with the ordinance will lose. If you can classify it in some other fashion and use the reasonable basis test, then most likely the party attacking the ordinance will lose. In the Belterre case, in discussing fundamental rights, the Supreme Court virtually did away with the allegation of a lot of important fundamental rights, and they did so literally in words of one sentence. In Petaluma, which Tony Catanese talked about, a federal district court judge found that interference with the market demand for housing created a violation of the right to travel. And they based this on cases in the area of income maintenance, where the number of states had placed restrictions on obtaining welfare until a residency requirement had been met. Anyway, the district court judge applied this to Petaluma and said that where they had a limitation on the number of new building permits, this violated the right to travel because it interfered with the natural access to the community, which would have developed because there were developers who were ready and willing to build. Belterra came along after the district court case and said, and this was all they said, the ordinance is not aimed at transients. And with that, they rejected an argument which had begun to appear in a number of cases and appeared likely to be very important, and no further reasons were given. They also rejected the notion that the Belterra ordinance violated the right to privacy, i.e. that people could live with whoever they wanted to live with, or that it violated the right to association. And they did so equally in words of one sentence. So that as far as Belterra was concerned, there was just a reasonable basis that was needed. After the Belterra case came along, the Court of Appeals handed down its decision in the Petaluma case. And although it overruled the district court case on technical grounds, on a different ground entirely, as Professor Catanese mentioned, because the developers were the parties bringing the case, and the court said that the developers hadn't been harmed in their right to travel. The court, in a footnote, made clear that if it were deciding the right to travel issue, it would decide it on the basis of Belterra and hold that nobody's right to travel had been violated. Subsequent to Belterra, the Supreme Court has also rejected the discrimination challenge. In the Arlington Heights case, which I think some of you may be familiar with, where a community had refused to rezone land to allow for low and middle income housing, the court said that in order to show that there was discrimination involved, you had to show that there was intent on the part of the community to discriminate. Prior to that decision, most of the lower federal courts that had handled cases like this had found that if there was a discriminatory effect, that was sufficient to produce a prima facie case of discrimination. And then the community would then have to come forward and show that in fact it had some compelling reason for doing so. I think in the Arlington Heights case, there were, in a community of about 50,000, there were maybe 25 or 35 blacks in the whole town. And the lower court had found that this was discriminatory. And I think in the county, there were about 200,000 people, and this was a suburb of Chicago. And there were only a couple hundred black families in the whole county. And the lower court had held that communities had an obligation to deal with the problem of discrimination. They, in fact, went further, I suspect, than they really had to do to decide the case. The Supreme Court held that you had to show motive to discriminate. And in deciding motive, it might make a difference as to the circumstances of the case. If, for example, the ordinance had existed on the books for many, many years, and the town had applied it in an equitable manner, in effect denying all apartment houses or developments, then it might be more difficult to find discrimination. On the other hand, if the town, as it had in a case in city of Blackjack, Missouri, had learned of a project and suddenly changed its ordinance to prevent the project from being built, that might make a difference. And the Supreme Court said there had to be a sensitive inquiry into such circumstantial and direct evidence of intent as may be available. And the sources of intent include historical background of events, departures from normal procedures, for example, statements made at meetings, inconsistent applications of policy. Now, one caveat came up under that, and that is that the court returned the case to the lower courts to consider the issue of whether under the Fair Housing Act of the United States, which prohibits discrimination in housing, you had to prove intent to discriminate. And the lower court of appeals, the Court of Appeals, when it redecided the case, said that under certain circumstances under the Fair Housing Act, you did not have to prove intent to discriminate, that it was not the same as the constitutional provision. The meaning of this is that for purposes, taking Belterra and Arlington Heights and putting them together, the use of the federal Constitution to raise discrimination challenges or fundamental constitutional right challenges against most growth control ordinances is simply not going to work. And attacks along that line will be very unlikely in the future using the Equal Protection Clause of the federal Constitution or any other clause of the federal Constitution. The Supreme Court, I might add, has also issued a number of other decisions which have made it increasingly difficult to bring lawsuits alleging discrimination. In the case of Worth versus Selden, decided, I think in '75, they held that in order to have standing to sue, in order to be entitled to bring the lawsuit, an inner city resident who did not own property in the community would not be eligible to bring the lawsuit. That the inner city resident only had rights through the developer who would be denied a building permit, and he was the person who was being injured. And this created a number of angry remarks by some dissenting judges who suggested that the Supreme Court was hostile to the views and attitudes and needs of the people who lived in inner cities. He decided there were other things in the case, but that's I think, the basic notion. And then in the Eastlake case arising in Ohio, the city of Eastlake, Ohio, passed an ordinance which required that there be a vote of the entire town on zoning amendments. And the exclusionary implications of this, I think, are fairly clear, but the Supreme Court said that this was an example of democracy, which I suppose it is, and that they weren't going to look at the other implications. Query what they would have done if it had been the city of Cleveland rather than the city of Eastlake, and every time somebody came in for a zoning amendment, the entire population had to go to the polls and vote. So the net result is that most zoning control, most control of growth, is now going to be at the state level, under state law. And barring, well, I shouldn't say barring, but until we see what is going to happen with the Fair Housing Act, it will probably be the case that many cases will be brought under the Fair Housing Act as lawyers turn from the United States Constitution to the Fair Housing Act. At the state level, again, we have a question of dealing with statutes and with the Constitution, state constitution. There are many states which have parallel constitutional provisions to the federal Constitution, an equal protection clause, and other clauses similar to First Amendment rights. These may or may not be interpreted in accordance with the federal provisions in the same way. The notion of regional welfare is something which has been raised at the state level and which has proven successful in a number of states, principally the state of New Jersey. There were a series of cases culminating in the Kitmar case, which held that communities could not stand in the way of individuals looking for a place to live, and that in the Kitmar case they overturned large lot zoning, said that 2 and 3 acre zoning was unreasonable because it was more than was needed, and they threw that out. Of course, one could always raise the notion that 1 acre zoning under that kind of a situation is really unnecessary as well. But most of the states have not really had a lot of zoning cases. And in the absence of the zoning cases, the only thing that one can say is that the question comes down to the situation of is the zoning ordinance a reasonable one? And therefore, if you deal with various techniques like either time development controls or large lot zoning, agricultural zoning, or other types of zoning which will restrict growth, the question really becomes, is it reasonable? Now, I suspect that what will happen is the number of state courts may very well go beyond that and take a fairly stringent view about growth control ordinances. I'm not sure I agree with Professor Catanese today that reasonableness will be the sole determining factor in the country from now on. I think a number of state courts may be rather stringent about it. Certainly they have been more stringent than the state courts in the area of school financing, and there's no reason to suspect that all the state courts will simply lie back and follow the Supreme Court. But again, a lot depends upon the court, a lot depends upon the statutes and the constitution of the states, and so it's going to be a very unpredictable situation. Some things may be unreasonable. An outright population cap saying no more than 40,000 people will ever live in this community, is likely to be held unreasonable in most situations. And Professor Catanese mentioned one of the cases this afternoon. Refusing to provide services where a city has a monopoly may well be a difficult problem. There was a case in Boulder, Colorado, where the city of Boulder refused to provide services to outlying areas, and the court said they had to provide the services because they had a virtual monopoly. What is clear is that most courts, in any event, will probably look fairly carefully at zoning ordinances. Generally, when they talk about the reasonableness standard, if you can find anything in the world to justify the ordinance, most courts will find that sufficient to uphold the ordinance. I think in this situation, what they will do is they say, as long as we can find that it's reasonable, we'll uphold it, but we'll want to make sure that you can prove it. So that means that there have to be adequate planning studies. If there's a reason for limiting building permits, it has to be clear that one needs to limit building permits. Now, this could even go so far, I suppose, as to allow a virtual stop on all development if it can be proven. There was a recent case in California, Associated Home Builders versus Livermore, in which the city essentially said that they were not going to allow any more building permits to be issued until they were satisfied that various planning standards, sewer standards, school, population problems could be dealt with. And they just simply stopped all permits. And that case was upheld by the California Supreme Court. Ramapo, of course, as you know, in New York has a time development ordinance which might make it possible for some areas of land not to be developed for a period of 18 years, and that was upheld on the grounds that it was reasonable. So there are a number of in other words, one can go fairly far under ordinances, but you have to be very careful that the groundwork has been done, and it's been done genuinely. I think courts are not going to just sort of accept figures and facts and rely on those, because they have no other standard for dealing with the ordinance except the notion of reasonableness, unless some of the states adopt more stringent standards. That's the area of zoning and growth control. I would like to say a few words about environmental law, although it's a rather large field and we can't cover it in any kind of detail. But as I noted before, in the 1960s there was a substantial pressure for new environmental legislation, and this resulted in the passage, starting in 1969, of a series of federal laws which have driven, apparently from talking to people, most planners in the United States completely up the wall, including the people who work for the federal government. There are two major areas in which these exist. One is in the area of decision making, and then the other is in the area of pollution control. I'm only talking about a few statutes at the moment, but the most important ones. In the area of decision making, there's the National Environmental Policy Act, NEPA, which was passed in 1969, which provides for strong environmental policy declarations on the part of the federal government. They say that the federal government is going to take an active role in protecting the environment, and it also provides for implementation measures to carry out this policy. And the most important implementation measure is the environmental impact statement requirement, which requires that federal agencies have to prepare environmental impact statements in all major federal actions significantly affecting the environment. Now, NEPA does not directly affect the local land use process. It may affect local land use decisions to the extent that, if you want to build a highway through a park, or if there's a major federal project, the land use implications of that have to be considered. But it doesn't directly affect the land use process, since the federal government doesn't really zone land. There are, however, a number of states which have passed state environmental policy acts. They're called SEPAs, modeled on NEPA. And there are about 20 states which have passed these laws. Some of them ape NEPA almost exactly. Some of them are less stringent than NEPA, and some of them actually go further in certain provisions. And in a number of those states, they apply to the actions of local jurisdictions, and this includes the projects of local jurisdictions as well as the permit activities of local jurisdictions. So that this means that environmental impact statements would have to be filed on such things as land use and comprehensive plans, zoning ordinances as they're passed, zoning amendments, which might have major environmental effects, subdivision ordinances, subdivision permits, building permits, grading permits, you can think of all the number of permits, and you can think of the number of possible situations where you might have to file one of these impact statements. Most of the impact statements also have to include in them a consideration of regional growth and development impacts as a result of particular projects. So that if a project is going to have impacts beyond the jurisdictional lines, these still have to be considered and taken into effect when the project is done. Some states also have requirements to minimize environmental damage. SEPA strongly administered could have an important effect on environmental planning. They have not been strongly administered in most states. The one state which has gone the farthest is California, which seems to go the farthest in just about everything. And I often wish that I were teaching in California, not in Ohio, because nothing ever happens in Ohio, literally, and nothing ever, and everything always seems to happen in California. I shouldn't say nothing ever happens in Ohio, but it's not as innovative as California by a long shot. But California has experienced a substantial activity in this area. The state of Washington also, Massachusetts, New York has recently adopted a statute and then postponed its implementation several times, and I think they're finally getting underway. The movement is, I think, stalled a little bit because California recently amended its statute, and I think a number of people are waiting to see what will happen. It's a nice idea in a way because it avoids making issues out of particular substantive matters in the area of land use. It doesn't say to the local area, you have to plan like this or like that. It simply says you have to write this document which indicates what you're doing. Surprisingly, though, in Ohio there was a land use review committee which last year, which essentially performed the same function, I guess, in a way as the committees we heard about today, although it was a committee of the legislature. And I tried in vain to convince the staff, which was one person, of the committee to consider the use of a State Environmental Policy Act, because I thought it might in some ways raise less opposition since it didn't mandate any specific kinds of planning at the local level. And apparently people get very upset about it. But it is a way of opening up decision making, of broadening it, of holding public officials accountable. And it does slow up the planning process. There are a number of questions as to how many impact statements should be filed. Obviously, you don't want to file an impact statement on every permit that the development needs. And there have been a number of articles discussing the question of whether to have one impact statement on an initial kind of permit, whether to have more than one, and what stages. But it's a potentially useful tool, and I think one which will probably increase in use in the future to some extent. In the area of pollution control, the two principal federal statutes are the Clean Air Act of 1970 and the Water Pollution Control Act of 1972. Both of these have recently been amended because both of them have run into serious problems, in many ways largely of the same type. That is to say, they're not being implemented. They both set up very complex sets of federal-state relationships. The Clean Air Act, for example, requires the federal government to set standards for pollutants, and the states have to prepare implementation plans to achieve those pollutants. I might note in the state of Ohio, which has, they don't have to applaud for me yet, in the state of Ohio, which probably has the worst sulfur dioxide problem in the country, the state has still not written a sulfur dioxide implementation plan 5 years after the original statute was passed. And the federal government finally promulgated one, and that's in litigation, and the state is now promulgating another one of its own. So you can see some of the problems that have arisen. The Federal Water Pollution Control Act is a little bit different, but you have the same kind of federal-state relationship. There are a number of provisions in both statutes which can affect growth control, I think, in the future. Most important under the Clean Air Act is the requirement that states deal with the problem of significant deterioration of air quality. Where air is cleaner than the standards, states are not automatically allowed to let the air deteriorate to the standards. In the statute that was, the amendments that were passed last year, almost all areas of the country were placed into a category which allowed for deterioration of this air, in terms of moderate, well-controlled growth, whatever that is. States can then redesignate certain areas either to restrict growth very stringently or to allow for substantially more growth than that. And I suspect that in the next couple of years that will become an important issue as a number of states begin to gear up to decide what areas they ought to redesignate. And clearly, areas which are redesignated to allow for minimal growth will not be allowed to grow unless new ways are found. Well, they're not redesignated to allow for minimal growth. They're redesignated to allow for minimal increases in pollution. But obviously, if new ways are not found to reduce the pollution arising from growth, that will limit the kind of population increase that you can have. In addition, metropolitan areas have to, in their plans, assure that they will maintain the ambient air quality standards and not simply meet them. And that, too, can affect population planning. If the federal government were to enforce the Clean Air Act the way it ought to be enforced, great many major metropolitan areas would stop growing completely. So the potential for land use and growth control is still there in the Clean Air Act. The Water Pollution Control Act is even more complicated than the Clean Air Act. It's sort of I like to think of it as living proof that the Baroque movement didn't die when Johann Sebastian Bach died. The only thing that makes it seem simple is the tax code. And in addition to these pollution control regulations, it also has, as you know, the 208 plans and the 201 grant money. And if these were enforced, they too would have an effect on growth control. I think the potential is there in the environmental field to vastly affect growth control. I think much less has been done, despite the screamings of a lot of local officials that they're really being interfered with by the federal government. I think by and large the federal statutes have not been as intrusive on local planning and state planning as they could be if somebody at US EPA decided to really let things swing. What will happen in the future, I suppose, is open to question. It certainly does not seem as though these laws will be rigorously enforced, but they will have some effect and should be taken into account. In summation, I think what we're likely to see for the next few years is a kind of very chaotic pattern, both in the area of environmental control, where we have new statutes which have been amended, and in the area of land use and growth control, where the Supreme Court has effectively removed the federal courts from the field for the most part, and has left the matter up to 50 different states, which have rather differing interests and rather different concerns. And I think it's going to be very difficult to predict from now on for a while what state courts are going to do, which means that it leaves the field open, certainly, for creative planning. And I think that, if planners, of course, one could say that if you don't have the facts, all planning is creative. But it leaves the potential open for planners to do things in the area of dealing with growth control, as long as they do it well and that they make sure that they do get the facts, and the planning is simply not a matter of reciting certain kinds of received dogma that they can then pass to the courts and the courts will accept. The courts, I think, will be increasingly stringent in looking at local zoning ordinances. I think that's basically what I have to say. I guess if we can take questions now, or do you want to wait until later?
Do we have any questions that?
In the play today, some of the objections were based on the city's